even if you think that upper line is meaningful.
Sorry. What do you, the word perpetual I'm having trouble with because it implies that it's entrenched and that a future Congress couldn't change it. But Congress could change it tomorrow. And there's nothing perpetual or permanent or about this.
So I think it's entrenched, Your Honor, in the sense that I think maybe the Chief Justice was referring to. Once Congress gives it over to the executive and expands executive power, you've now given, a co-equal branch of government a large amount of your power, and you need to claw it back. You can't claw it back through an ordinary law. You can only claw it back through either convincing the president himself to give up presidential power, something you've given to him, which is tough to do, or you've got to override a presidential veto.
If a member or House of Congress tomorrow, if a majority of a House of Congress said we're not going to fund pick your agency unless we change the CFPB funding structure, they could do that.
Sure, Your Honor, they could do that. But nonetheless, once you give up power to another agency, you've suddenly flipped the baseline for getting it back. Right. You do need to use those very powerful tools and ultimately override a presidential veto or convince the president to give up his own authority. Which
right.
is
I agree with you on flipping the baseline. I agree with you on that. But just the word perpetual or forever or permanent, I think, is a little strong here. Then on the independent point, you said Congress had created the most independent agency in American history. And I certainly agree that as originally constructed, the CFPB had, in my view, a massive constitutional flaw in the single director who was protected by for-cause removal. But that, of course, was fixed and addressed in seal of law. And now it's not independent at all, at least as the term independent is used. It's under the direct supervision and control of the president. So I don't think it's, correct me if you think that's wrong, but it's not independent.
They certainly fixed half the problem, but they didn't fix the other half of the problem in our view. Look, everybody knew what was going on in 2010. The 2010 Congress knew that there would come a time when future Congresses didn't look so favorably upon the CFPB. And they wanted to insulate a future CFPB from political pressure from a future Congress. And that's precisely why they adopted the funding regime that they adopted. But future Congresses are supposed to have the ability to check the president through a continuing power of the purse. It's meant to be a continuing check on executive power. And to come back to the fundamental problem of the transfer of that frontline determination to the executive branch, to the director. As far as this statute is concerned, I will even concede for the sake of argument that wide band is a meaningful one. Within that band, if the director picks $150 million or $600 million, it's perfectly fine from Congress's perspective, because Congress simply said to the board, you make that determination. And that top line number isn't even a real number, because they can further evade it by building out this continuing endowment that would